Let's get some analysis. We're now joined via Zoom by Joselynn Fember, attorney and managing partner at Fember Attorneys Inc. Thank you so much for your time this afternoon, Joselynn. Now, given today's revelations that the NPA in Gauteng found that the docket that the defense has spent some time on had no merit, what implications will this have on the state's case, especially because both dockets were in the public arena even before this trial began?
Yes, that's correct, Unati. I'd just like to also put that into perspective. So the matter was postponed last week to give the defense time to address two issues, and that's Advocate Sandile Mshololo. The first issue was that of Exhibit C, and the second was that Advocate Mshololo would indicate when the matter can proceed after consideration of the contents of that second docket. Now, in the bigger scheme of things, several concerning issues have already been raised during cross-examination, including, the admissions that have been extracted by Zandile Mshololo from Thabo Mosia during this process. Some of those include, of course, the possible contamination of the crime scene, the failure to take crucial DNA evidence, so many irregularities in the chain of custody of the exhibits, and so on and so forth. Today's proceedings were quite brief in that Sergeant Mosia was not on the stand. However, the matters discussed were largely limited to those two issues, and then obviously the additional issues that have now come up that were raised by Advocate Tefo. Docket number 1 is the docket that is relevant to the current proceedings, and docket number 2 is the additional docket naming different suspects for the offences of murder and defeating the ends of justice, and that is docket number 375 of 2019. Now, the issues that arose with this docket are twofold. First, it is the furnishing by the state to accused number 5 of the actual copies of the docket. And secondly, the awareness of the existence of the docket by the defense. Now, in regards to the awareness of the existence of the docket, the state has indicated that on the 25th of January this year, formal counsel for accused number 3 requested further particulars in respect of that second docket. Apparently, there was a letter which was opened and which was recorded by the colonel and the warrant officer responsible for the matter. So the state is saying that the defense was aware of the existence of the docket. The issue of the second docket was also extensively raised by Advocate Tefo during cross-examination. So I think it suffices to say that this wasn't actually a bombshell, so to speak. It is the lateness of the disclosure of the contents that is concerning in this matter. And what seems critical is that the state knew that this docket existed in respect of the same incident, but that it failed to discharge its duty to subpoena the contents of the docket from the SAPS. The fact that and this was raised today, that Advocate Baloyi or the state was aware of this and allowed the accused to plead without taking steps to avail those documents and statements in the current docket is problematic for the accused and accused number 5 in particular. What happened this morning is also quite peculiar, and this is that irrespective of the fact that these proceedings were postponed last week, Wednesday, for this very reason, the state introduced 2 letters into the record. Those letters were undated and unsigned. This was pointed out by Advocate Mshololo. And those letters stated that no decision was made by the DPP in Gauteng on docket number 2. It was stated that the memorandum contained in that docket was of no legal consequence because it was prepared by a junior state prosecutor and it was intended to actually be an internal opinion. So interestingly, the proceedings were interjected with the introduction of a second letter, and that was only a few seconds later, which seemed to be a correction of the first letter. There was a short adjournment, and I think that the second letter only contained a minor amendment, but it states that the DPP again was distancing itself from the docket and that the documents in that docket do not have any status and that they are without merit. So in essence, the DPP did not decide to charge any person named in docket number 2. In my opinion, these last-minute exchanges of correspondence and amendments thereof demonstrate a lack of preparation by the state, and this only compounds the public's opinion that this matter has not been handled in the way that it should be.
Very quickly, because we're running out of time, just to explain for the benefit of our viewers and also for myself, I mean, you mentioned that this shows a lack of unpreparedness, for the state. What can we also make around the way in which this matter was handled by the NPA? I mean, one would assume that instead of an unsigned, undated letter, that this would be part and parcel of the trial in terms of their submission, instead of having these exchanges that seem very much, as you say, showing a lack of preparedness.
Yes, certainly. I think that there is an administrative way of discharging a decision to prosecute, and the way in which the NPA is expected to deal with matters of such seriousness. What Advocate Mshololo submitted to the court is that accused number 5 needed to be informed about the reasons for the decisions taken in the second docket. Whether she's satisfied by those reasons in light of her client's rights will only be revealed when the court reconvenes, because she has submitted that she has to consult with her client and consider the nature of the application that she intends to bring as a result of these constant delays. And these delays are being blamed on the state. So it doesn't look good for the NPA. And there is, the fact that the docket was given to Advocate Tefo, for example, in Advocate Baloy's presence, and not given to Advocate Mshololo or the state, is concerning when one considers that when the trial commenced on the 22nd of April, the state did not request to compel these particulars by way of subpoena, and the state has the power to do that. If, for instance, SABC had refused to provide Advocate Baloy with those documents, he had the power to subpoena them, and the fact that he didn't do this is very concerning.
All right, it'll be interesting to see then what transpires tomorrow. Joselynn Fember, thank you so much for your time this afternoon. Really do appreciate your analysis. Of course, Joselynn Fember, attorney and managing partner at Fember Attorneys.